This today was what we're going to cover is the Statute of Frauds, which was first passed in England in 1677. It was an act of Parliament, of course, and it's important to understand the purpose of the statute because it might surprise you. It was not to prevent fraud amongst the contractors. It was to prevent frauds upon the court, to preclude perjuries, that was. In other words, a lot of people were perjuring themselves about contracts in England, and it was becoming very disgraceful the way they were using the courts to cheat other people. And so this act was passed, and basically what it said is that certain named contracts, like a contract for a sale of an interest in land, had to be in writing. And basically it didn't say that exactly. It said that thereafter, in order to prove the existence of a statute for the sale of land, you had to have writing to prove it. So that was what it was, a signed writing. And so this was to prevent frauds on the court. And of course, nowadays people think of it as preventing frauds amongst the contractors, and to some extent maybe it does, but then again it might be used perversely, as any sort of statute could be used. The courts, on a motion by the litigant nowadays, will dismiss a case in the absence of a written contract upon which the case was brought. So if you brought a case arguing that somebody had breached the contract with you and therefore owed you some money, the court would basically have the pleading in front of it. And the court could see that it didn't have a writing, but typically it wouldn't say anything. And so basically, if the other side has a lawyer, that lawyer would raise the objection and make a motion to dismiss the case on account of the statute of fraud. And the judge then looks at the pleading and says, well, you did not attach a writing to the pleadings. Do you have a writing? And if you have a writing, I'll allow you to amend this pleading by, including this in the document. Do you have that writing? If you don't have the writing and you don't bring up an exception to the statute of frauds, the court will dismiss the case. That would be the end of that case. So you wouldn't win the case, you would have lost the case because you weren't able to prove the existence of the contract that you said was breached. And so that's the way statute of frauds works. So it's very summary in some ways. Okay, now the statute names 6 kinds of cases that needed to be in writing. The first one would be one involving an interest in land. Most people want to know that if you're selling real estate, you need to have land. But it's any interest in land. It could be a lease of a certain duration will be required to be in land by most states. It can be other things. We'll talk about all the things that it includes as we go along. And a second one is where the terms cannot be performed within 1 year, you need to have a writing. And so that 1 year starts on the day it was formed. The day of signing, maybe, because that may not be the date of the formation of the contract. The contract might have been agreed to before that. So technically, we talk about the contract oftentimes as being the document, the writing on which the words of the contract are laid out. That's simply the document. That's simply the proof of what the contract was. The contract is this agreement. It's an abstract kind of thing. It has a separate existence from the document, but you cannot prove the contract in court without having the document. But there are exceptions to it, meaning that you can have a contract for these things, even for any of these 6 contracts. You can have a contract without having a writing. That's why it's a little bit of a misstatement to say that the statute required that you have a contract. It's only the statute requires, if you want to prove the contract, if you have to prove the contract, that you have a writing. So the terms can't be performed within 1 year, then that's the kind of contract that has to be in writing. So it's possible to perform it within 1 year. You don't need to have a writing. But if it cannot be performed within 1 year, you do need to have a writing. Also, a promise to pay the debt or perform an obligation of another. needs to be in writing. So insurance contracts, an insurance company agrees that if you're sued, they will pay for a couple of things usually. If you're sued in a car accident, they will pay for your attorney who represents you, and they will also pay if you're found to be liable for any damages that you have done. And so that's part of what they promise for in an automobile insurance contract. So a fourth kind of contract was the promise to pay the debt of a decedent. A decedent is not another because he's no longer here. So they had to specifically lay that out. Now, why would you need to have both of these? Well, because sometimes in these situations, people would say there was an oral promise. For instance, if you were selling something to a man and his wife happened to be rich and you knew it and he didn't have the money to pay, you might want to allege that she promised that she would pay if he didn't pay. Of course, we now know, of course, that you would have to have that kind of collateral promise in writing. So you have to have her co-sign the note. And we'll talk about maybe later about co-signing the notes as either a maker or a endorser or another capacity. So a guarantor. Okay, the promise. So these two kinds of promises are basically being obligated to pay somebody else's debt. Perhaps the person's dead, then it's a decedent. In any case, you need to have a writing to prove these. So this protects executors. Oftentimes, when a person would die in England, the creditors would worry about whether or not there was enough money in the estate, but also whether or not they would get paid. And of course, if there wasn't enough money in the estate, they wouldn't maybe not get totally paid. And so they would put pressure on the executor. And they want the executor to pay them ahead of time. Of course, the executor couldn't pay them ahead of time because he had to wait till the case went through probate. And so they would put pressure on him, though. And if he said, "Oh, don't worry, I promise you'll get paid," was he personally promising to pay them? Probably that was not his intention. Probably he meant that I promise that I'll pay you out of the estate. So that could be a misinterpretation. Or it could be just an executor, just a debt creditor trying to get some money when he knew that there wasn't enough money in the estate, that he's trying to get some money by claiming that the executor had claimed it. And, it was also possible then to have somebody perjuring themselves. So remember, the statute was there to prevent perjuries on the court and to protect the court from losing its good reputation. Okay, promises are made in consideration of marriage. Nowadays, when I first studied law and heard this, I thought, are they talking about dowries? Nobody does dowries. If you marry my daughter Susan, I give you 3 pigs and a cow. Nobody does that. No, they're not talking about that. Although sometimes there might be some sort of arrangement for somebody to get something if people married. So it's not uncommon maybe for the parents of the bride and the groom to maybe make an agreement. Maybe they decide they want to both chip in and buy their children a nice house so they get a good start in life. So they might agree to buy a house and each of them are going to put in $60,000. So they'll have $120,000 to give them a house. And so then they'll maybe be able to start right away with a house. I mean, that would be a very nice thing. And that's a contract between these two people, and it's made in consideration of marriage of their children. Also, of course, nowadays, we oftentimes have prenuptial agreements. Prenuptial agreements apply when a couple is getting married. Oftentimes nowadays, a divorced couple, oftentimes 2 divorced people, meet and they decide they want to be married and they want to remarry, but not to their ex-spouses certainly. And so they enter into an agreement as to what happens if they die. So one of the things that would happen in a divorce would be children might be worried about if their parents remarried, what's going to happen if my parent died? Am I going to get the house? Am I going to get anything? Or will the new mother or father, my mother or father's spouse, will they intercede and take the property? And so the prenuptial agreement would be something that you could show your children and say, here, that's not going to happen. Also, people who go to foreign lands to maybe marry some person, men going to maybe the Ukraine or Russia or some other country, might enter into a prenuptial agreement with the foreign bride. They maybe don't know her that well, and they're worried about that. Certainly, people who have a lot of money oftentimes have in the past, and to this day, maybe have a contract that they require to be signed before they marry that new spouse who basically doesn't have money, because they want to know whether or not they're being married for the money, and if they are being married for money, they want to protect that money. So you find it being very much something that we still have to this day. Contracts for the sale of goods over $500. Now this has been changed largely by most states, in that they have increased the amount, which was long overdue. It was $500 for years. So I remember I have a business law textbook from high school when my mother went to high school. And in her high school textbook, it talked about promises for $500. And I'm going to school in the 70s and the 80s. And I'm saying to myself, well, you know, $500 then was a lot more money than it is in my day. And yet it hadn't changed. So it hadn't changed for years. It was that way for over 100 years. Nowadays, that has been adjusted by inflation, for inflation in most states. And so, but we still use that when we teach it, just so we have a figure that we can talk about. It's going to be different in different states, maybe. $500 or more, you have to have that contract for the sale of goods. $500 or more. Okay. Sale of services, well, only if the service entails a product, and therefore could be classified as being a product sale rather than a service sale. And some sales are kind of a mix. You go to a hairdresser and you want your hair dyed, and she gets a bottle. You pay for the hair dye, and you pay for her putting the dye on your hair. Which is it? Is it mostly a sale of a good, or mostly a sale of a service? That's something that each court would have to work out for itself. And in the states, that's probably been pretty well worked out by different states. Interest in land. Interest in land includes contract to sell or lease, as I mentioned, but also mortgages. And would you want this to be in writing? Real estate agency agreements, pay the agent some percentage of the sales price, which is usually what the buyer contracts for in selling his house. I'm not the buyer, I'm sorry, usually the seller contracts for that. The buyer sometimes enters into contract, and some there might be two agents who are getting a cut from the sales price. And also, I don't know whether they have these in Indiana, but I know that, in some states there's still existing sharecrop contracts where somebody lives on and works somebody's field and basically agrees to share with him the profits. So basically that has to be in writing. It's an interest in land. The sharecropper gains an interest in living on the land and an interest on the crop that is grown on the land. And also I want to mention the equal dignity rule here. The equal dignity rule requires that an agent's authority be in writing if contracts the agent will enter into on behalf of the principal require a writing. So that's the case. Also, this is applied in situations where you have a partnership, or say a lawyer or an accountant or a dentist or a doctor. Oftentimes a professional might enter into a partnership. In some cases, the party who the partnership that he enters into already owns as a partnership a building that they operate out of. And in that case, by entering the partnership, by becoming a partner, he acquires an interest in land. Therefore, that has to be in writing too. That's called the equal dignity rule in many states. Promises to pay a debt of another. Co-signers are classified either as co-makers or endorsers, so we talked about this. If you co-sign a note, you want to know basically in what capacity you're signing the note. Are you guaranteeing payment, and are you a guarantor? This is an important distinction. What they are depends on what they promise. Co-makers promise to make payments as they become due. If they do not do so, the default is personal to them, and they are primarily liable. Their rights and their liabilities are limited to those of a maker. The guarantors and endorsers, also known as sureties, will have to pay, but they have rights of a surety, and one of those rights is that they are only secondarily liable. Secondarily liable means that they don't have to pay when the amount is due, but they will have to pay after the default, and so they become obligated to pay after the default. But they can insist, as one of the rights of surety, that the creditor, the person who, the party who was the agreed party who didn't have his didn't get the amount paid that he was promised, that person could then would then have to pursue the maker to litigation and have to pursue him to having the litigation returned in his favor and having it returned that actually the debtor continued not to pay the amount, and so even after a judgment he's ordered to pay, but he doesn't pay, and then the guarantor, the endorser of the contract, has to then pony up the money and pay. So it's very important to read and understand what you're doing if you're being asked to co-sign a note, to understand what exactly is your liability. One thing that's important is that whether you're a co-maker or whether you're a surety, if there's going to be a default, you have to have notice that there's a default so that you could come in and maybe redeem the property before it was actually sold at auction. Because if you did pay the debt, you're entitled to recover. You're entitled to recover for the amount that the car is for the amount of the debt owed, not necessarily the amount that the car would be sold for at auction. So the car might be worth more than what it's being bought for at an auction. Upon default, upon being repossessed and sold, it might bring a lot more than what the debt was. The primary debtor, the person who you co-signed for, let's say it's your son, then would get that difference for that, but you would get that money if you were his father, and you would then have control of that money. And maybe that would give you some leverage in order to bring him to a more sensible lifestyle. Anyway, so it's important to understand what your rights are. And so it's important to understand whether you're a guarantor, an endorser, or whether you're a co-maker by co-signing. There's also another exception to the rule that provides that if the main purpose of the collateral promise serves the purpose of the guarantor. So in an oral guarantee of payment of another's debt, the guarantor has the benefit of avoiding litigation under the Statute of Frauds, except when that guarantor in making the promise can be shown to be serving a substantial or leading benefit of his own. Then the promise need not be in writing. So that promise, in other words, a person who says to a creditor, don't worry, you'll get paid, and the creditor agrees to allow maybe some leeway, gives an extension of time, and never gets paid, and actually his situation deteriorates as a result of that. He doesn't wind up getting as much money, because if he can repossess the good, maybe he can sell it. Obviously, if it's the sooner you repossess it, maybe the better. And so this rule says that if his main purpose in making that promise was to serve himself, as in one case where a person co-owned the business with others, and he persuaded the bank not to foreclose, to give them an extension of time, and he promised the bank that he would make sure that it got paid, even if he had to pay it himself. But he never signed it. And of course, so that's a collateral promise, and the bank should have insisted that he co-signed the note. He didn't. But since he was serving a main purpose of his own, the bank was able nonetheless to require him to pay on that promise, even though it was oral. So, other exceptions. Admissions in court. Now remember, I said that this was to prevent fraud upon the courts. So admissions have to be stated in the courtroom. It's no good if I've got a client and my client basically is going to assert a contract and he doesn't have a writing. He entered into a partnership, and you can do this. You can enter into an oral agreement of partnership, and you don't need necessarily a contract to do that. When you enter into that contract, you can't prove its existence. Now, if you enter a partnership, the partnership was not listed as one of the contracts required to be in writing by the Statute of Frauds. You say, well, it doesn't apply. Well, it does, doesn't it? Because actually, if you enter a partnership, as I said earlier, if in entering the partnership you gained an interest in land, it is in the Statute of Frauds then, right? And so, so you need to have that writing, even though you say, well, all I did was join this partnership, and so you would need to have a writing to prove the existence of that partnership contract, if it's a contract. And oftentimes these partnership agreements are contractual, as well as matters of partnership. So anyway, so the first one is admission in court. So if you can, what would happen, say, if my client wanted to deny the existence of a contract, and he admits to me as we're talking, he maybe even admits in negotiations with the other side that he had agreed to make this fellow a partner. So my client wants to assert, wants to deny this contract. Okay, well, I would go to court for my client, and I would, at the beginning of the case, I would stand up and say exactly what I said I would say earlier. I would say to the court, I'm making a motion to dismiss this case on the Statute of Frauds. And like I said, the court will then look at the pleadings, and on the pleadings on such a case, there should be attached the writing upon which this contract was made. So the document that some people call the contract should be attached to that. So he looks at it and he says, well, there's no writing attached to this as proving the existence of the contract. Do you have such a writing? And at that point, we can only they can only say no, and or if they say yes, then they're told, well, they need to come and attach it to the document. We can examine it to see whether it's authentic or not. And my client says there wasn't any sign. Maybe they forged their document. Well, you can actually prove forgery because it has to have his signature on it. So it's not only a signed writing; it's not only a writing; it's also signed. And so that admission has to be in court. It can't be during the negotiations. It has to be made in court. And so there's no need to prove its existence before the court other than having the other side admit it. So how does that ever happen? Well, it would only happen if I, as an attorney representing a client who wants to assert the statute of fraud, don't do my job right, commit malpractice, and fail to assert the statute of fraud at the very beginning of the case. If that other attorney puts my client on the stand and asks him a series of questions starting with, do you know the plaintiff? Did you meet with the plaintiff? Did you talk about this business? Did you come to some sort of arrangement? He might even go further and say, did you come to an understanding? Just if he can admit that there was some kind of arrangement, that might be enough for a court to decide that there was actually a contract because they had this arrangement. That sounds like it might be actually a contract, doesn't it? And so the court could say, okay, I'm going to hear this case. And what you really want is get the case dismissed at the very beginning, which is why it would be malpractice if I didn't stand up and say, I move to dismiss this case. And, On the other hand, the other side would maybe like to claim some kind of exception to the rule. And so we're going to go through the other exceptions. Are there any other exceptions that he might be able to use in this case? Well, he can't use the full or partial performance, even though they may have operated as a partnership for a time. He's not going to be able to use that, the fact that they were operating the business together. So it's going to be a matter of testimony as to under what the conditions are under which they were operating as a partnership. So the contract performance has to be full or partial. This usually applies in cases such as you go to a furniture store and you buy some furniture for your living room, and so you buy the full kind of living room stuff that people usually have in a living room. So you have a couch, you have a love seat, you have 2 end tables, and you have 2 end chairs. You have 2 side chairs, and you have a coffee table, and maybe you have some lamps, maybe stand-up lamp, maybe also some table lamps, and the other things that you want in your living room. You buy all this furniture, and then the sales clerk who sells you this fails to have you sign the contract. He brings out to sign the contract, but you don't sign it, and he doesn't notice that, and so the contract isn't signed. You leave there, and nonetheless they deliver the goods to you, and when you get a shipment of the goods, it's not all there, but you accept what's there. So they deliver the couch, they deliver the love seat, they deliver one of the chairs and one of the tables, but the rest of it is not delivered. The contract is within the statute of frauds because of the fact that it's probably going to run over $500 to buy that amount of furniture. Okay, so and if the amount of furniture that was delivered was over $500, your case is cinched. You will not be able to deny the contract to the extent that there was a delivery. You'll have to pay for those items that you delivered, and if you signed a receipt, that may also be used as the proof of the existence of the contract, as the writing that proves the existence of the contract. But if nothing else, it at least proves that you did receive this. All they have to do is prove that you did receive these goods, and so that would be maybe a partial performance. So in a partial performance, it's an exception to statute of frauds, but you only get for that. You only have to pay for that which you have received, not for the part that you didn't receive. And this could apply also to contracts involved in installments where you're supposed to have 3 shipments of something and you accept 2 of the shipments but not the 3rd, and then you try to deny the existence of the contract. You're going to have to pay for the first 2 shipments maybe, but not the 3rd because you didn't accept that. Contract for another exception is contracts for specialized or customized goods. So these are contracts made to your order. If you go to a tailor and he measures you, and then he tells you to return in a week or so, or he tells you, give you a call when it's done, he then makes the suit to your specifications, to what his measurement said would fit you the best. So that's a specialized good, it's a customized good. And how likely is a person who does that kind of work going to measure somebody and then make the goods for that person if he hadn't signed the contract? Not likely, right? More likely it would be a case where he had a contract, thought that the fellow had signed it, but the fellow didn't sign it and said it took off. And maybe the fellow was thinking, well, if I don't like the suit, I'll just say I'm not going to pay for it after he's finished with it. And the tailor's gone through all this effort to actually customize this suit. He's putting in a lot of hours, and he's not getting paid for his work. So you can see that it seems more just in this situation for him to be able to assert that this man did come into my shop and ordered this suit, and I did measure him, and look how well it fits him. You know, he doesn't like it now because he suddenly decides that he doesn't like the way the colors are. But he chose those colors, and we talked about that in warranty. You know, he chose the colors, he chose the kind of suit it was. Does it have a vest? He chose to have a vest or not. he chose an Italian suit or whatever kind of suit he chose, you know, he's going to be held to have to pay the contract price in that case, or show there's something defective about the suit. And so that's his problem. Anyway, so that's specialized goods. It also occurs in cases where maybe you have an automobile. And when I was young, they would take automobiles that didn't have air conditioning, because there were a lot of cars in that didn't have air conditioning, didn't come with air conditioning from the factory. And they would install air conditioning into these cars. And this was a specialized kind of contract. And so those kinds of things would have to be in writing. Or another thing that was happening is there sometimes were pizza parlors that were opening in downtown locations and in these old buildings. And these old buildings didn't have air conditioning, and the pizza parlor wanted to have air conditioning, so some guy would have to come in there and install the air conditioning. That would be a specialized goods. And you know, nowadays actually furnaces are oftentimes put in. They're specialized, right? Because they have to map out the air ducts. So anytime you have a good that's specialized, another example would be a foreign dictator who comes into the country and goes to a car dealership that is going to specially modify a car that's going to be designed to protect him with armor plates and machine guns and whatever. That would be a specialized goods. I don't think they do that anymore. I think that the manufacturers take care of that kind of business. I mean, that maybe they even have those kind of special salesmen who kind of bid for those dictators' jobs. Anyway, but it's still a specialized goods, and therefore you do need to have a writing in any case. Agreements between merchants is a fourth exception. Agreements between merchants in which one of the parties has sent a sufficient written constitutive confirmation to the other. Promissory estoppel, where one party relies on promises to his detriment, is another. So let's talk about agreements between merchants. Okay, so this happens, let's say, in something like growing a crop. Let's say you're a farmer and you grow a crop of corn. You go to a state fair, and at the state fair there are men there who will approach farmers and ask them if they're interested in selling corn. These men are, you know, middlemen who work for large grocery chains maybe, and they basically need to line up a number of farmers who will agree to sell their entire crop and pay so much and be paid so much per bushel. Of course, the farmers don't know how much crop they're going to have, because it's something that happens in the future, and some disaster could happen, and they could have crop losses at the very end of the season. So there's some uncertainty as to how much money the farmer is going to get from the crop. And what the price is for the crop in the future is largely going to be determined about how large the size of the crop is. If there's a lot of corn, the price would be lower. And you're then fixing a price at that time if you agree to a contract. Maybe the farmer doesn't want to fix the price. If he doesn't want to fix the price, he just should tell that middleman, that agent, no, I'm not going to sell it at this time. Once I harvest it, I'll be willing to negotiate the sale of it. If he thinks that the crop is going to be large this season, and he thinks the price is going to be falling, maybe he would agree if he can get a good price for the person. So it's somewhat a matter of negotiation. Usually the middlemen are better at it than the farmers. Okay, but there is a negotiation there. Anyway, once they signed it, they're both going to be fixed to that price. Now you can write a contract in a way that the price will be adjusted. There will be an adjustment to the price. You know, you could write it as if the price was going to be fixed as of this date, and then you could make an additional. You could adjust it for inflation, or there's any number of ways you could determine a price in the future that doesn't cause you to commit to a fixed price that may be too low or too high, depending upon which side of the bargain you're on. And so anyway, they enter into this. Farmers oftentimes will maybe say something to an agent, and the agent will believe he has a contract with this farmer, and he will send to the farmer a memorandum stating, we met on this day, and you agreed to sell me your crop of corn for X amount per bushel of corn, and I'm to get the entire crop. And so that's pretty much what it says. and it'll probably require the agent to come out, send somebody out to pick up the corn, or maybe the farmer is to bring it in, whatever the contract says. So anyway, you have this contract, but the farmer knows that he never signed anything, and so if he's like a lot of people, he thinks if he didn't sign anything for the sale of his crop, that there's, you know, you're basically selling something that has an interest in land. If you're selling crops, it's required to be in writing by statute of frauds. So he says, well, I don't have a contract and there's a statute of frauds, and therefore I'm not compelled to deliver these goods to him or to hold them for him. And so he just throws the memorandum away. Now that's a mistake. In fact, if you get a memorandum, what you should do if you're the farmer is write to the agent that, no, I did not agree to set the price, I did not agree to this contract, and therefore we don't have a contract. So you need to notify him that you don't. You're considered to be a merchant as a farmer because every year you're selling your crop. And by the fact that you intend to grow it to sell it, and the fact that you're doing this on a repeated basis is enough to show that you're a merchant. Now, if you are a farmer who does not sell his crops at the end of the year, let's say you're an Amish farmer, and what you do is you take whatever crops you have and you take them down to the Amish church, and basically all farmers bring their goods down there and they're distributed to the entire community. So you're growing for your consumption and for the consumption of your friends at the church who are going to share their crops with you. In that case, you're not arguably a merchant, and therefore you might want to claim that as an exception. So you have to be selling it on some sort of regular basis. If you're not selling it, you're just, you know, providing it for every member of the church to take whatever they need. You're not exchanging it to them for their goods. They're going to share with you. You're going to share with them. It's not that kind of arrangement. It's not like you go down there and dicker with them how much corn they're going to get and how much tomatoes you're going to get. You just simply say, well, this is what I need. They'd say what they need. Everybody takes it. If that's the case, you're not a merchant. So there is a definition of merchant in the Uniform Commercial Code. And it says that if you sell your crop for a profit and on a regular basis, you are then a merchant. So promissory estoppel is also an exception to the statute of frauds. Promissory estoppel, where one party relies on promises to his detriment and the promisor is unjustly enriched. Now I have to tell you, these are the 5 exceptions that you could say that are recognized by most people. There is in some states a 5th exception where one could assert that one was a victim of fraud, but that the party who they were basically negotiating with, let's go back to the partnership case. Let's say that you want to argue to the judge that my client was being defrauded. He was entering into a partnership and he didn't know that he needed to have it in writing. He didn't think of it as being a contract required to be in writing. He's not a lawyer, and he didn't have legal advice. On the other hand, the other side did have legal advice, and therefore, why didn't they put it in writing? Well, it must have been that they intended to commit fraud. If they changed their mind about the partnership, they could get out of the deal and take my client's money in the process. Well, that would be an exception that's only been recognized, I believe, in just a couple of states. And in those cases, it's not even clear. In the state of Ohio, it's been recognized in a trial court only. And a trial court is not very good precedent, right? So you need to get it approved by an appeals court. That case wasn't appealed, but a trial court recognized that as an exception. Unusual. Sufficiency of the writing. It must be in writing, basically. Now, but what is a writing? And on the modern terms, the definition of writing might quite surprise you. A writing includes any paper document, including receipts. And I mentioned that before. If you signed a receipt, that might be proof of the contract. If it meets other requirements of a writing, which are going to the terms being spelled out, and that there needs to be a signature. So a signed receipt, which might indicate that this was a contract, that there was an intent to contract, and indicate what was being exchanged, what the consideration was for both sides, might be adequate. Memos, letters. In Indiana, we have a case involving a woman who had entered into an oral agreement with her husband as to the division of the property when because they were going through a divorce and they hadn't gotten to divorce yet. So before divorce was settled, she met with her husband and they agreed as to who would get what. You know, who would get the farm, who would get the truck, and who would get the furniture, and who would get the dog. You know, and all these things that people might want to agree upon ahead of time. And it's typical in these kind of situations for you to do that with your lawyers. And of course, your lawyers would make sure that both of you have a signed agreement. But neither one of them thought of putting this memo in writing. However, she later, after discussing the division of property with her husband, sent a letter to his mother, her mother-in-law. And her mother, when during the divorce, produced that letter on behalf of her son. So she said, I got this letter from her, and it was signed. The signed letter indicating that we had come to this agreement. Didn't say contract, we had come to this agreement. And I think that probably her lawyer was completely blindsided. He didn't know anything about this letter. And, you know, so it comes as a surprise to him that, why didn't you tell me about this letter? You know, and probably says, she said, oh, I didn't think the whole thing was, I didn't sign anything at the time. And I didn't realize this letter could be introduced as proof of the existence of the contract. That's because people think of the contract as being a document. What did I say at the very beginning? Contract is not the document. The contract is this abstract agreement. It's a mental kind of thing. So, you know, it's a very good ideal to have it in writing. Obviously, you need it in writing in many of these cases, and if you don't have it in writing, you can have all kinds of problems. And so, this proving it is a problem. Now, also, an electronic record can indicate the parties have an agreement and state the consideration of all the parties. You know, you need to properly document that recording at the time. Have both parties sign some sort of documentation that this is a recording of what your agreement is, because you still have the signature requirement. And so the second thing that makes the writing sufficient. So the first thing is that you have to have something to prove the contract existed. Okay, and it must be signed by all the parties. Signatures required is often met by a type, a name, or even initial signatures can be placed anywhere in the document to prove the existence of the contract. Only the party denying the contract thus has no formal document is required. And also, it's required that the terms are adequately represented in the writing or in the recording, or whatever it is that you're asserting is your proof of existence of the contract under the Statute of Frauds. So you do need the proof of what the terms of the contract are. You need to include those terms in there sufficiently, adequately, so that somebody could tell what it was that was agreed upon by the parties. That is, that the court can tell what it is. Otherwise, you'll likely find there's no contract in existence. But by this document, it doesn't show a contract because it's inadequate to show it, because he doesn't know what this contract consisted of. What was it that was agreed to? So yeah, you have to have both parties' names, and you have to have their terms of contract in there also. Now, some final words. Let's end with a joke. It's a little bit of a fun now. Tell us, how many animals of each type did Moses take on the ark? The answer will be on the PowerPoint slide that follows, so I'll make these PowerPoint slides available to you. Anyway, statute of frauds cases revolve around proving that certain contracts exist, whereas the parole evidence rule revolves around proving what the terms of the contract are. On tests, students often make a mistake of confusing statute of frauds with the parole evidence rule. Why do they do that? I think it's maybe in some cases for the same reason that they confuse it in terms of the joke that I just said. How many animals did Moses take on the ark? You know, it wasn't Moses. It was Noah. And so the answer to that was he took no animals on the ark. He wasn't on the ark. You know, he parted the Red Sea. And if I asked you a question like the parole evidence rule requires a a sale of an interest in land to be in writing, the answer would be that would be false, because parole evidence rule doesn't require a writing for that purpose. It requires a writing to prove the terms of the agreement. It doesn't prove a writing to prove the existence of the contract. And so I've seen that question produced on many tests, and I think it's a little bit of a tricky question. So I'm going to warn you about it. Thank you very much.